State of Michigan versus Jeremiah Ford, 26-00301. Appearance, please.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Good morning, Your Honor. Attorney Derek Etheridge, and also the public defender on behalf of Mr. Ford, who is in the courtroom standing to my right.
The board is scheduled today for a prelim. This is for assault with intent to do great bodily harm, domestic violence. It looks like there was an offer for him to plead guilty. Re-amending count 1 to ag assault. So
That's correct, Your Honor.
okay, and he's going to plead guilty to count 2 as well.
That's correct, Your Honor.
And there's a killer brew, which is a sentencing agreement between you and the prosecutor of no upfront jail and no objection to 769.4A. That's correct?
That's correct, Your Honor.
You understand that to be your plea offer? And you would like to accept that offer? Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Thank you.
Okay, you can take your hand out your pocket and put your hands up. Okay. This is a advice of rights and plea information sheet. There's a signature on it. Is that your signature?
Yes, sir.
Did you go over these rights with your attorney?
Yes, sir.
Do you understand all of these rights?
Yes, sir.
And you're willing to waive them today in order to plead guilty to count 1 of an aggravated assault and count 2 domestic violence?
Yes, sir.
Okay, and you understand that you are presumed innocent until proven guilty. So you can maintain your innocence, take this to trial, require the prosecutor to prove each element of each of the charges beyond a reasonable doubt.
Yes, sir.
And at the time of trial, you have the right to remain silent and not have silence be used against you, the right to waive your silence and take the stand and testify on your behalf, the right to subpoena witnesses that will testify, the right to cross-examine or question any witness called to testify against you. You understand that?
Yes, sir.
Is anyone threatening you to get you to give up any of these rights?
No, Your Honor.
Has there been any promises not stated here on the record to get you to waive your right to enter a guilty plea to these charges?
No, ma'am.
You understand that the killer brew, I'm not a party to that, so I'll decide how you're gonna be sentenced. You understand that?
Yes, ma'am.
So I could decide that you're gonna do upfront jail. You understand that?
Yes,
If I were to do that, I would give you the option to withdraw your plea, okay? Are you currently on probation or on parole?
No.
You don't know?
I don't know if I.
You're on bond for
No.
this case, but do you have any other criminal matters?
No.
Okay, so you're not on probation or on parole. You understand that a guilty plea could result in a conviction that you may need to report to your employer, or you may need to put this conviction on a future job application.
Yes, sir.
It also could have an impact on where you can go on vacation or travel, or where you can get immigration status. You understand that?
Yes, sir.
As to count 1, amended count 1 of aggravated domestic violence, how do you plead? And count 2 of domestic violence, how do you plead?
Guilty.
And is that because you believe you're guilty? Actual basis, please.
Yes, Your Honor. Thank you. Mr. Ford, I'm going to draw your attention to January 30th of 2026. Were you at 6820 South Cedar?
Yeah.
And that's in Lansing, Ingham County, state of Michigan, correct? And you had contact with an individual named Ashley Marie Griffin, correct? And you had a contact with Ashley Marie Griffin, correct? January 30th. You know
Oh, yeah.
You okay?
Yeah.
And Miss Griffin is your girlfriend?
That's
Ex-girlfriend. At that time, she was your girlfriend, though, correct? And at that time, you and her had some type of disagreement and argument, correct?
Yeah.
At that time, you pushed her, correct?
Yeah.
And that matter escalated, and you pushed her again, and she suffered some bruising and a scratch to her neck area, correct? And she went to the hospital to receive medical services for the scratch and the bruises, correct?
Yes.
And you don't dispute that she had to go to the hospital for medical treatment, correct? Yeah, you don't dispute that, correct?
Correct.
And you did not act in any type of self-defense, correct?
Correct.
Your Honor, that would cover both counts, I believe, sufficiently.
People are satisfied.
Okay, just for my clarification, this is 2 separate DVs for 1 incident.
There were 2 separate instances of pushing, I believe, attested to.
Yes, Your Honor.
On the
There was-
same date,
On the same date,
Same
correct?
date, yes, Your Honor.
same time?
Correct.
Yes, Your Honor. They were around the same time where there was one and then it escalated and then there was another push that caused.
Okay. That's for the ag.
Yes, Your Honor.
Correct.
Got it. Okay, the court is satisfied with the factual basis. I'll accept your plea. Find your plea to be freely, voluntarily, and intelligently made. This matter is scheduled for sentencing April 17th at 9 a.m. You need to go downstairs when you leave here to our probation department so they can get you scheduled for a pre-sentence interview. They'll prepare a report and advise the court about how they believe you should be sentenced, okay? Do you have any questions at this time? Any additional matters for the record?
No, Your Honor, thank you.
No, Your Honor, thank you.
You're all set, thank you. We do this, I gotta get around the courtroom. You know what it is?
I don't know where the source is coming from.
Oh, Jesus.
Yeah.
Someone needs a request to adjourn. Running Hawkins,
We're running Hawkins.
what's going on with Taylor?
Taylor, he was not read over. My understanding is he's in a different jail. Mr. Green is Eaton County, yeah. Mr. Green is also new to the case and we're asking for an adjournment otherwise.
State of Michigan versus Christopher Taylor, 24-00563. Appearance, please.
Good morning, Your Honor. Abigail Wilson for the people.
Thank you, Your Honor. Vince Green on behalf of the defendant, Christopher Taylor.
Okay, it looks like he was just booked at Eaton County on the 17th, so we
That's
were
correct.
not advised.
Yes.
Okay.
That's right.
And then you're new to the case.
Yes,
Did you get discovery?
we received it yesterday afternoon.
I just signed the substitution of counsel. Let's see. Due to the defendant recently being booked at Eaton County and not present today, the court's gonna find the cause to go beyond the 21 days and reset this matter.
Thank you, Your Honor.
Thank you, Your Honor.
Does March 5th work for you?
Yes, it does, Your Honor.
9:30.
Perfect. Thank you.
Any additional matters for the record?
No, Your Honor, thank you.
Now to the defendant, Your Honor.
Thank you. And then we're running walk. What's going on with
No,
walk?
that is going to be a request for an adjournment as well.
State of Michigan versus Devon Walk, 26-00264. Appearance, please.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Thank you, Your Honor. Attorney Burnett Levine on behalf of Devin Watt, making my way to the podium and my clients directly on my right side. Present.
States the date that was scheduled for a preliminary examination for criminal sexual crime, first degree, false imprisonment, and domestic violence. I do have an appearance from you, counsel. Did you get discovery?
We did. Your Honor.
Okay, and what's the reason for the request to adjourn?
Thank you, Your Honor. It's my understanding that Mr. Levine received some pretty critical discovery just recently that he needs to go over with his client. And that would probably drastically change what we're going to be doing with the preliminary exam. So for those reasons, for the defendant's willing to waive his 21 days and we're requesting an adjournment of the exam.
That's correct.
You understand that you have the right to have a preliminary examination on these felonies within 21 days of the date that you're arraigned?
Yes, Your Honor.
And you're willing to waive the timeline so that your attorney can have additional time to review discovery?
Yes, Your Honor.
March fifth at 9, which I think you're here for something else already, Mr. Wine.
I believe the following day, but that's.
Oh, it's the next day. Okay, so that day works for you?
It doesn't appreciate the court.
Any additional matters for the record?
No, Your Honor, thank you.
Likewise.
You're all set. State of Michigan versus William Davis, 25-01395. Appearance, please.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Lucas Stone on behalf of William Davis appearing via Zoom.
My understanding is it's set for a bond motion.
That's correct, Your Honor.
Okay, what's the issue?
I believe this is a defensive motion, so I will defer to Mr. Dillon.
Counsel?
Mr. Davis missed a PCC when the court was out in front of Judge Buchanan. My office failed to give him Zoom information in time. He did get the Zoom information, attempted to log on and could not. That's the only reason for his FTA. His case in Shiawassee has been resolved. Me and attorney Joel Martinez are resolving this matter with what we believe to be a dismissal. I'm asking that he have a PR bond be reinstated.
Oh, it's not, or I guess Buchanan must have handled more than one PCC. This is not the first time he's missed a PCC.
I was not counsel of record for what he did miss once I was involved. He has appeared at every single court date. The reason that he missed the one was my fault. If the court wants to institute fines against me, I'm fine with that. But he did attempt at that time to get on and join.
Wait, how was it your fault?
My office failed to give him the Zoom code in time. I logged on, he was attempting to log on, and the court said he was not in time and revoked his bond at that time.
Yeah, because how old is your client? He doesn't need you to give him Zoom login. He knows he's got a felony pending.
Understand, Your Honor.
So it's
He was-
nice
he
to
was
try
a-
to pass the buck on another individual, but he knew he had court. He was advised personally that he had court.
Correct. He
Just
switched
because you
counsel.
didn't get the Zoom, just because you didn't get the Zoom ID didn't mean you don't log in. You could come in person. Zoom is an option.
I believe the court was out and then it went to Judge Buchanan. He switched counsel in that time. I know that he failed to appear for something else, but he's been in constant contact with my office. That situation happened. He's engaged in no wrongdoing in this matter, and we do anticipate a dismissal. It should be a note in Ms. Wilson's file that they've attempted to locate the victim and to no success, and we anticipate it'll be dismissed.
The court not being present had nothing to do with this court date. Just because I was out didn't mean that changed who was here in the monitoring our Zoom and or another judge handling the PCCs. That's common practice here, is another judge handling our probable cause conferences if one is not here. None of those things had anything to do with your client for the second time failing to appear for his court case. Maybe and I don't know, I'm going to give the prosecution an opportunity to respond. Maybe the reason why they can't find the victim is because it's been so long and he failed to appear in 2025. I don't know. Counsel?
Thank you, Your Honor. I see a note about Mr. Martinez having a conversation with Mr. Dillon. However, that conversation does not indicate that we are dismissing. We're in the process of trying to locate the victim. We're making our way. We've had some contact with her father. So that's not currently our position, as I understand it. As the court's made a record already, Mr. Davis has failed to appear a couple times. Sounds like he's picked up other charges in a different county for weapons, which certainly cuts against the safety and community consideration the court has for bond. I believe we have our next court date on March 3rd, which I believe is not March 3rd, coming up in a few weeks. I don't remember the exact date, March 6th. So I'd ask that this court just hold off until then so we can figure out what's happening with the case.
That can be heard on that, Your Honor.
It's PCC, the 27th of February. Oh, next week. So there's a probable cause, yeah, it's in the file. There's a probable cause conference is scheduled next week, the 27th, and a preliminary examination is scheduled on the 6th. Let's see. I'm trying to read this handwriting, but no motion. Okay, looks like Judge Buchanan has already denied emergency motion to modify the bond. You can be heard.
Thank you. I've been attempting, prior to the motion in front of Judge Buchanan, we attempted to get a bond hearing in front of Judge Milmore or Magistrate Milmore for 2 months. The case in Shiawassee has been resolved with no jail and HYTA status. The only thing holding him is this court in this matter, and that I would leave it at that. I'm not sure why there are no notes about what Mr. Martinez and I've said. I take the officer of the court, Ms. Wilson, as her word. But again, if the court wants to put a tether on him, I've been attempting to get him out for 2 months here. And again, it's his fault. And I understand what the court is saying, and I agree. But you will have no concerns with him appearing or not at any court date. I understand we have a PCC coming up. But I'd ask if the court is concerned about appearance, that he can be fitted with a tether, and he will be at every single court date.
Is he on a remand or do we have a bond? Yeah, last thing I seen here was a remand. I don't see anything since then. It looks like Ward did a remand. No, he's
When he was just
remanded.
doing his first bond was 5,000.
That was revoked. It looks like Judge Ward signed this last week. I don't know why.
It's a very confusing case, Your Honor. Everything that can go wrong has gone wrong in this matter.
Why did he see Judge Ward last week?
He
Let's
was
see.
arraigned right here.
Oh, he missed the PCC and we just saw him.
No,
He
was in
failed to appear October 24th, 2025. Then there was an emergency motion that Judge Buchanan denied in December. It looks like there was a video arraignment that was scheduled for February 17th. Is that because he was in custody in another jurisdiction?
He was released from Shiawassee jail. He was transferred to Ingham. I wasn't notified. They had a bond motion without me being present and denied bond. It was on a Saturday. I've never had that happen before. We had been waiting for that bond hearing on the 17th for 2 months. I appeared at that time, and Magistrate Milmore said there was nothing she could do. This court graciously granted me this date early, and that's why we're here.
What day you say, the 17th, you before Milmore when? February 17th?
Yes, ma'am.
Oh, yeah, Milmore wouldn't be able to address, if he's already been arraigned, I don't see how she could address it, I don't know, but it says here, he saw Judge Ward on the 14th.
And I was never noticed. I didn't have an opportunity to speak. It was on a Saturday morning, and they just remanded him.
Okay, so I'm confused. He never turned himself in on the failure to appear?
No, he was because of that failure to appear, because of that Zoom situation, he was transferred to Shiawassee, given no bond because of the failure to appear. That case has since resolved with no jail, no further upfront jail, and HYTA status. He was transferred to Ingham, seen without counsel, without me, and remanded with no bond on a Saturday morning. I was set
Got
for
it.
the 17th, and Magistrate Milmore said he's already been arraigned. You can call Judge Simmons. This court bumped it up before the PCC so I could be heard.
Got it.
I would note, just as another factor, his father has driven from Mississippi 3 separate times to attend certain hearings, and everything's gone wrong. So he does have community support. He's retained counsel. His other case is totally resolved. And like I said, if the court's worried about non-appearance, would graciously pay for a tether.
Okay, it looks like he was already ordered to be on tether anyways. I'm gonna issue a bond 5,000 personal recognizance for GPS tether. There's a no contact order in place for the protection of is it Mollis Jones? You're not to have contact directly or indirectly with that protected party. Do you understand that, sir?
Yes, Your Honor.
You also understand it is your responsibility to keep up with your court dates and keep up with how you log in and or appear in person. It's not your attorney's responsibility to spoon feed you that information. Do you understand that?
Yes, Your Honor.
We're telling you here on this record that you have a court date for a probable cause conference on the 27th at 8:30. That's next week. You figure it out how you're going to be here, whether it's in person or via Zoom, but you can't later put it on your attorney because your attorney didn't send you the Zoom login. All of our Zoom logins are on the court website. We also give you the Zoom login when we give you your notice to appear if you're in custody of our jail. So it's not outside of your realm to be able to figure out how to log into our Zoom. You understand that?
Yes, Your Honor.
Okay, also you have a preliminary examination scheduled for March 6th. You have to appear in person for that date. Do you understand that?
Yes, Your Honor.
Not to be within 2,000 feet again of the alleged victim. You will wear GPS tether with victim notification if possible. What address are you residing at?
900 Long Boulevard,
What apartment?
548.
What's your phone number?
I don't know it by heart. I have a new number.
You say you have a new number?
Yes, ma'am.
Who knows your phone number?
Oh, my dad.
Is his dad here?
His dad resides in Mississippi. His phone was seized, Your Honor. We don't have it back yet. I have his father's number.
Okay, so you get in contact with him through his father?
Yes.
Okay, so how was the court supposed to have communication with him?
I mean, I would have to relay the information. The court just gave him all his court dates. If he misses, I don't know how he would.
Yeah, how is JSG supposed to contact him if he's in the exclusion zone?
He would have to get a phone number. Mr. Davis, didn't you have an alternate number?
Yes, I still have it. I just don't remember it by heart.
I have it.
just got.
I have it.
Okay,
I
Mr.
have
Dillon,
that
if you
other phone
can
that
get
he
that
had. I have the
information to
number.
the court, Mr. Dillon, if you can provide that information to the court, he can't be released on GPS tether if the court can't get a phone number for him.
I do have it, Your Honor. And how would I go about having his dad pay for that? Because he doesn't have any funds.
How would you go about having his dad pay for what, the tether?
Yes.
You gotta contact the county. They can, or JSG, I'm sure they can set that up for him.
Yes, ma'am.
Yeah, the father or the father can contact, but first, we need to have a phone number. Once you provide the court with the phone number, I'll amend the bond.
I will provide it shortly, Your Honor.
Okay, thank you. Any additional
Can I
matters
see-
for the records?
No, Your Honor, thank you.
You'd only just email it to your staff, Your Honor.
Yes, please.
I will do that now.
Thank you.
Thank you.
that was Davis. Go with Damon. Who's on Zoom? Okay, Mr. Davis is free to go because he's all set. Sharonda Lewis is a forensic. I see Mr. Mills outside. Is he? Mills was out the window about 30 minutes ago. I figured. Mr. Etheridge, you have Marquez Robinson.
Yes, Your Honor.
Are we running that?
No, Your Honor, it's my understanding that alleged victims have been feared.
Let me call the hallway one more time first.
Mr. Powell is present.
Yes, ma'am.
Mr. Doyle, are we running that next week? Oh, he doesn't have a date. That's the issue. Let me see, State of Michigan versus Deshaun Powell, 26-00335. Is Akeem Johnson here?
He is in custody, I believe. Mr. Raleigh spoke with him and he was accepting a plea offer.
Oh, he's downstairs?
I believe so.
Oh,
That was my understanding.
he's not highlighted in our thing, okay. Appearance on the.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Okay, Mr. Clerk, Daniel, on behalf of Mr. Powell. Can I get 2 minutes from my lawyer?
Excuse me?
Can I get 2 minutes from my lawyer?
Well, not right now. Today's the date set for probable cause conference. And we never set this for an actual exam date, did we? No, it's actually scheduled today for exam, but we said we were gonna treat it as a probable cause conference. Let's see. In your conflict counsel that you got discovery?
Yes, sir.
Okay. It sounds like you still need to speak with your client because he needs 2 minutes. How are we expecting to proceed on this?
We are continuous to the exam. We're still investigating.
Okay. Let me get you an exam date, and then if you want to log in and speak to Mr. Powell, you can do that afterwards.
March 5th at 8:30.
Is March 5th at 8:30 work?
Yes, Your Honor.
Any additional matters for today's record?
No, Your Honor, thank you.
No, yeah.
Thank you. Mr. Powell, your attorney's gonna log in and meet with you now.
Yes, ma'am. Appreciate you.
No problem.
Johnson is not in ICJ. I don't know if he's in another county, but
Johnson's not an ICJ.
Oh, well, Mr. Raleigh went and spoke to him somewhere.
Okay, so you did call the witness, call the hall for
Yeah,
Mr.
I
Robinson.
have no one, so we're ready to move forward with it.
State of Michigan versus Marquez Robinson, 26-00324. Here.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Morning, Your Honor. Attorney Derek Estes, Office of General, on behalf of Mr. Robinson, who's in the courtroom standing to my right.
Mr. Robinson is scheduled for a preliminary examination on assault with intention to great bodily harm less than murder. And we do not have a witness today. How are we proceeding?
I expect a motion from the defense to which the people have no response.
Thank you, Your Honor. At this time, we'd ask the court to dismiss the matter without prejudice. I've already spoken with Mr. Robinson, explained to him statute of limitations. This could be reissued within statute of limitations, which appears to be 6 years. I discussed him not having any contact with the alleged victim for at least 48 hours in order for the no contact provision to be removed from lien. He would advise the court that he does have a bond that he paid the court and that he is currently on tether.
Very good. So we will grant the motion without prejudice. He can go and have the tether removed. And you've been advised of the people's right to reissue. Do you have any questions?
No.
Any additional matters for the record?
Not for the people.
No, Your Honor, thank you.
Thank you. We'll get your dismissal in just a moment, sir.
Thank you, Your Honor. Mr. Robinson, just sit outside. and I'll get to this.
Mr. Raleigh,
Yes, Your Honor.
how are you?
Morning, Your
My understanding is that you spoke to Akeem Johnson.
I did.
Where?
Here, outside.
Oh, because he's not in custody.
Johnson is not.
Okay.
She has a call.
For who?
Mr. Mills.
For Mills? Okay, State of Michigan versus Sharonda Lewis, 25-01108, appearance, please.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Assistant Public Defender John Lee on behalf of Sharonda Lewis.
For a long time. Okay, this was set for review. Did she was ordered to go to have a forensic evaluation, it appears, is that what happened? Yeah. And then she's been on warrant status. Did we get a response back? Did she ever? I don't know that she ever appeared. This, I signed this, this was from May. You might need a new referral.
Okay, Mr. Milks advised me that she was waiting to be seen while she was in jail. So I don't know if he has been in touch with CFP and that's his understanding, or if he needs a new referral, I'll let him know.
Yeah, my note here from September is that the defendant failed to appear for the forensic evaluation. So I issued a bench warrant with a remand. It's possible at this point we need a new referral. That one was from May, almost a year ago.
Okay. We'll get on that ready.
Okay. Any additional matters for today's record?
Not for the people.
Not for the defense.
Thank you.
Thank you.
Nothing new.
You're all set, Ms. Lewis.
Do I get out?
Absolutely not. You're remanded until we get a forensic evaluation.
How long is that?
I don't know.
You don't know when I get out?
I don't know when you're gonna get out. You were ordered to do a forensic back in May. You failed to appear. So now we have to wait for your attorney to submit a new referral. And then the forensic center will have to schedule a new evaluation. And I have to hold you in the custody of the jail to make sure that it's done.
I have another court date?
Not at this time. It's gonna be set for a review, but the attorney should be getting me this paperwork today for a new review, evaluation.
And then I'll know today? How do I know? They're gonna let me know?
You're not going to know about the forensic until it's scheduled. So you won't get any information until your forensic evaluation is scheduled, and the jail will make you aware of that, okay?
I have to stay here, right?
You absolutely have to stay there until that's done.
Okay,
Thank you.
thank you.
What are we doing with Beeman?
That's gonna be a dismissal.
State of Michigan versus Cyrus Beeman, 23-03159. Appearance, please.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Your Honor, Jeffrey Kaplan, 274943, on behalf of the defendant who is approaching.
This was a preliminary examination scheduled for carrying concealed weapons, felon in possession, and other weapons charged, and the people wanted to dismiss.
That's correct, Your Honor. At this time, the people are unable to sustain their burden of proof and are requesting a dismissal in this matter.
I'm assuming there's no objection.
I haven't spoken to my client about it, but I'm pretty sure he's not going to object.
Do you have any questions? Okay, we'll get you a dismissal in just a moment.
Thank you, Your Honor.
Thank you. Mr. Rowley.
Today's 20th.
Oh, yeah. State of Michigan versus Akeem Johnson, 26-00336. Here,
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Jacob Riley on behalf of Mr. Johnson, who's present to my right.
Mr. Johnson was scheduled today for a prelim on pleading abuse. How are we proceeding?
Thank you, Your Honor. It's my understanding that Mr. Johnson is going to be accepting a plea to an attempt plea and elude a police officer in the 4th degree. That's a misdemeanor punishable by up to 1 year and or $1,000.
That's correct. Here's the paperwork. If I may, just-
Please. Mr. Johnson, that's accurate. I raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. You understand that you have the right to the presumption that you're innocent until proven guilty. And you understand that you can take this matter to a jury trial, require the prosecutor to prove your guilt beyond a reasonable doubt.
Yes, ma'am.
And that means that you would have the right at the time of trial to question or cross-examine any witness that they were going to call to testify against you, the right to call your own witnesses to testify on your behalf or present evidence you believe show a defense to these charges, your right to remain silent at trial and not have silence be used against you, or you could testify at your own trial if you like. You understand those rights?
Yes, ma'am.
You're willing to give all of those rights up? Sure.
I know what
You do. You have the option to have a trial.
I'd rather get them right, so
Okay. Okay. And no one's forcing you to give those rights up.
it's just the best thought of me.
Okay. And no, so no one's forcing you though.
No, nobody.
No,
forced me.
no promises being extended to you to get you to give these rights up.
No,
Okay. Are you on probation?
no, no.
Are you on parole?
No, no.
You understand that if a guilty plea is entered, it could result in a conviction that you have to report to either your current job or put it on a future job application.
Yeah, and that's kind of really where I'm at in life, because the type of field I'm at, like, I just got denied for 2 jobs because of, like, it's on there right now.
You just,
But yeah,
you understand that though?
yeah, I
Okay,
understand.
so that's not a hindrance for you or concern?
It is, but I'm cool with it.
Okay. You also understand that it could have impact on where you could travel or get immigration status?
Yes, ma'am.
Okay. As to the amended count 1 of attempted plea, a police officer. Under the penal code, how do you plead? No, not how does he plead, how do you plead?
Yes,
Is that because you believe you're guilty?
yes, ma'am.
Okay, factual basis?
Mr. Johnson, on February 4th of this year, 2026, were you driving a vehicle in the area of Pleasant Grove and Dunlap Street? Is that in the city of Lansing, state of Michigan? Yeah. While driving that vehicle, at some point, did you become aware that there is a police vehicle behind you following you? Yes. That vehicle activate its lights, like they would if they wanted you to stop? You understand at that point that they were likely trying to get you to stop, they wanted you to stop? Yeah. Is it true that you did not stop, that you kept driving for some distance and did not intend to stop at that point? Yes.
Any questions from the prosecution?
Nope, people are satisfied.
Finding the plea to be freely and voluntarily made, I will accept your plea. This matter is set for sentencing. It's gonna be April 17th at 9 a.m. You need to go downstairs to meet with probation so they can provide the court with a pre-sentence report, okay? So they'll schedule you for an interview. And then you can appear via Zoom for your sentencing if you have video, okay? You have any questions? Any additional matters for the record?
No, Your Honor, thank you.
No, Your Honor, thank you.
We're all set. In Clinton County, Wade? Yeah. Who's covering for Silver Dome? You know?
I'm trying to find out.
State of Michigan versus Ryan Perkins, 26-00204. Appearance, please.
Good morning, Your Honor. Abigail Wilson, on behalf of the people. Karen Robinson, Assistant Public Defender for Mr. Perkins.
Okay, Mr. Perkins was scheduled today for a prelim on aggravated stalking, and then there was a domestic violence. Are we running an exam?
Your Honor, I believe this is going to be a plea. I just need to fill out some paperwork real quick.
What was the offer?
The offer is 1 count of domestic stalking, that's a misdemeanor, 1 year and or up to 5 years probation, and 1 count of domestic violence.
Okay, he just needs to do his the rights and rights.
Correct.
Okay. Are we running Wiseman?
It didn't sound like it, but Mr. Raleigh scooted out. Sounds like that one's gonna be a plea as well. Yeah, let me double check this. Yeah.
We don't know who is covering for Wade.
That's a big one. Is that
Right, but it's the weird fines and costs, so I don't know that he's eligible is the issue. So. Or we can just put it.
What
we
if
can
you
put
were
it,
to
and then if he's
expand?
not, then.
Yeah, county.
Like, I don't understand.
Yeah, I gotta have a question. Davis's phone number.
No, not yet.
No, you have from his district. So,
Yeah, I only, well, I read it from his office that he's on the line this morning.
got it. I'm gonna give you this. That's the one he's gotta give me a phone number before we can amend the bond.
Okay, thank you.
For Wade. They. March 19th. March 19th for Wade.
Okay.
until we reset Wade for March 19th.
Okay, thank you.
Council, you can approach. Back on the record in the matter of State of Michigan versus Ryan Perkins. Okay, so Mr. Perkins, the offer was for you to plead guilty to 1 count of domestic stalking and 1 count of domestic violence, correct?
And Your Honor, I did speak to Ms. Wilson, and they will consent to 7694A if he is eligible.
That's correct, Your Honor.
That's correct, sir. Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, sir.
Okay, you can put your hand down. This is your signature here. You've gone over these rights? Okay, you gotta speak up loud enough so the system can
Yes.
hear you, okay?
Yes, ma'am.
Okay, so you understand that you have to give up these rights in order to plead guilty?
I do.
So that means you're gonna give up your right to the presumption that you're innocent, the right to require the prosecutor to prove your guilt beyond a reasonable doubt at a jury trial, your right to remain silent and not have it used against you, your right to question or cross-examine in court any witness called to testify against you, and your right to subpoena witnesses to testify on your behalf, correct?
Yes.
And no one's threatening you to give these rights up, correct?
No.
Anybody coercing you to plead guilty?
No.
Are you on probation?
No.
Are you on parole?
No.
You understand a guilty plea might need to be reported to your employer?
Yes.
And it also could have impact on where you can travel or get immigration status. As to the amended count 1 of domestic stalking, how do you plead?
Guilty.
As to count 2 of domestic violence, how do you plead? Factual basis.
Yes, Your Honor.
Wait, that's because you believe you're guilty?
Yes.
Okay, factual basis.
Mr. Perkins, were you on August 26, 2025 at the area of 1130 Dorchester Circle, apartment 10 in the city of Lansing, county of Ingham, state of Michigan?
Yes, sir.
And at that time, did you come into contact with a Michaela Mead?
Yes. She invited me over. We were gonna talk.
Okay, and with Ms. Mead, you previously had a romantic relationship with Ms. Mead, is that correct?
That's correct.
And during that date and time, you and Ms. Mead had an altercation, is that correct?
That's correct.
And at that point, did you eventually pick up a glass bottle and throw it at Ms. Mead?
I did.
And at that time, you also briefly left the residence and came back, is that correct?
I was just there one time. I don't know what the hell it was. So I said, listen. There was no me coming there and leaving, coming
Hold
back.
on. And did you previously have an active personal protection order out against you by Ms. Mead?
Yes, you did.
And that was preventing you from going anywhere near Ms. Mead, correct?
Correct.
Or any residence that she's located in, correct?
Huh? Yeah. Even if it still needs to be like 2 or more.
And did you previously have a contact with Ms. Mead on a date and time that was before this incident in August?
I don't recall that.
On the date before the, while the PPO was given?
Just the date of the incident we're talking about now. I don't recall any other different dates. Just the one time.
Can I have a moment, Your Honor?
Absolutely.
Was there one day? There was only one time when people was there.
All right, Your Honor, Mr. Perkins has changed his mind. He wants to run his preliminary exam.
You can have a seat. We'll call you in just a moment. So let's see, we're running that one. We're running Hawkins. And what about Wiseman?
Wiseman, Mr. Raleigh said he was pretty sure was gonna be a plea, but then he ducked out, so I'm not sure.
His headache, it's just so much going on. What was that? That was something I wanted to make me a sinus headache.
Says on your plate.
Okay, it can be brought up. No, it was crazy. Finally, it's percolating. On the record in the matter of the state of Michigan versus Alan Wiseman, 26-00323. Appearance, please.
Jacob Brown, on behalf of Mr. Wiseman, who is present.
Right now.
Appearance.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Okay, today was the date that was scheduled for interfering with electronic device. My understanding, he's going to plead to amend count to domestic violence, and upon successful plea and sentence, people will dismiss count one. Is that accurate?
That's correct, Your Honor.
Yes, Your Honor.
Do you want to accept that offer, sir?
Yes, ma'am.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? You can put your hand down. This is an advice of rights, plea information sheet. There's a signature on it. Is that your signature? Then you went over these rights with Mr. Raleigh, correct? You understand that you have the right to maintain these rights and take this matter to trial, maintain your presumption of innocence, and have the prosecution prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any witness called to testify against you, the right to call your own witnesses or present evidence that you believe show a defense to the charge, and the right to waive your silence and testify at your own trial. You understand that? Anyone threatening you to get you to give up these rights and plead guilty? Any promises if you plead guilty to count two? Are you on probation? Before which court? Can you speak up?
Ingham County.
Before the 30th Circuit Court? Okay, which judge?
Jamie.
Until when?
Got 2 years probation, so
You said what?
I have 2 years probation.
You just got placed on probation?
No, man, I've been on for about a year, and a couple months.
Okay, so you still have a few months or several months. Okay. You understand that by pleading guilty, it could result in a violation of your probation status? You also understand that it could result in a conviction that you may need to put on a future job application, or you may need to report it to a current employer. It also could have impact to where you can travel or get immigration status. You understand that?
Yes, I do.
As to domestic violence, how do you plead?
Yes.
Is that because you believe you're guilty of domestic violence?
Yes.
Factual basis?
Thank you, Your Honor. But Mr. Wiseman, on February 4th of this year, 2026, were you at location 3933 Phoenix Drive?
Yes.
Then in city of Lansing, Ingham County, in the state of Michigan?
Yes, it is.
And was a person named Natalia Tori also at that location?
Yes, sir.
Is this somebody that you had a dating relationship with and they had children in common with?
Yes, sir.
What did you do on that date at that location that would make you guilty of assaulting?
Hey, with the blown.
Yeah, with the probe.
Yes, sir.
Were you acting in self-defense at the time?
No, sir.
And is it true that this is not something she wanted you to do or give you permission to do? Okay, thank you. I believe that's a factual basis.
People are satisfied.
People is also satisfied with the factual basis. I'll accept your plea. I find to be free, voluntarily, and intelligently made. The victim here.
She is, Your Honor.
What is he on probation for?
It looks like that is a felonious assault.
Proceed to sentencing if the victim is already here.
Okay.
Does the victim want to give a statement?
She does not want to.
You can address the court, Mr. Rowley.
Your Honor, given the fact that my client is under supervision through the circuit court and it seems a probation violation is in process there. And he has a hearing, I believe, scheduled for March 26th at this point. My request would be for the jail sentence on this case. I don't think it's necessary to place him on additional probation supervision. And I will also note that he has been in custody since May 4th on this case.
Does he want to say anything for himself? Yeah.
I'm sorry to the victims and the state of Michigan for my actions. I truly do apologize for how I acted.
I don't know what's going on with your matter that's before the circuit court, but obviously you got some issues that need to be resolved, and you're gonna need to do some really deep soul searching and some cleansing, because for you to believe that it's acceptable for you to put your hands or use weapons to touch anyone else's children, it's just it's outlandish, it's crazy, and you lack self-control. So you need to figure out how you can gain control of yourself before you end up spending the larger portion of your life behind bars. It's just unreasonable. Women should feel protected by men and not feel threatened, unsafe, and should not be harmed at your hands. You understand that? And I don't know what goes on in your brain or what goes on with you emotionally that makes you think that this is acceptable. But I would hope that you get this under control. 93 days Ingham County Jail. Credit for any time served. No earned earlier release. He'll serve no additional earned early release. He'll serve the additional time in Ingham County Jail. Any additional matters for the record?
No, Your Honor, thank you.
No, Your Honor.
I'm gonna pop out to talk to a witness real quick just to see if
Take
they
your
can.
time. I got this one.
Perfect.
Are you waiting for something, sir?
She said I changed my mind. I just think the fact.
Oh, yeah, you're gonna have an exam. That's right. I believe it's the 20th February. Good Lord. Oh, no. We blinked and February got 8 more days. Daddy, we gotta get our life together. Okay, we're back on the record in the matter of the state of Michigan versus Ryan Perkins. And my understanding is that Mr. Perkins is going to move forward with just the count two of domestic violence, correct?
That's correct, Your Honor. And upon successful plea and sentencing, count one would be dismissed.
Okay, still no objection to 769.4A.
That's correct, Your Honor. The lien that we have in his file is reading a little wonky. It looks like he has a prior domestic that was dismissed, but there's something about fines and costs associated with it.
Okay.
So I think probation will need to run their own lien just to confirm, but if my understanding is correct, he should be eligible.
Sounds good. We've already gone over his rights. If you want to re-elicit factual basis just for the DB.
Sure. All right, Mr. Perkins, on August 26, 2025, at 11:30 Dorchester Circle, Lansing, Michigan, or City of Lansing, County of Hingham, State of Michigan. Were you at that location at that date and time?
I was.
And did you have contact with a Michaela Mead?
Yes, I did.
And you previously had a dating relationship with Ms. Mead, is that correct?
That's correct.
During that date and time, there was an altercation between you and Ms. Mead,
Yes,
and you threw a glass bottle in her direction?
that's correct.
People are satisfied?
Accept your plea, find your plea to be freely, voluntarily, and intelligently made. Sentencing is April 17th at 9 a.m. When you leave here, you'll go down one floor, check in with probation so they can get you scheduled for your pre-sentence interview. They'll look into whether or not you're eligible for 769.24A as well, okay?
There was one other thing I was asking.
Yes.
They didn't put a tether on me because they didn't think I was going to come to my court dates or something of that
You
matter.
can have the tether removed.
Okay, thank you so
Let me
much.
note that on the file.
Sorry.
You just go back to JSG or to the county to have it removed, okay?
Can I do that today?
Absolutely.
Thank you so much.
No problem. Any additional matters?
No, thank you, Your Honor.
No, Your Honor, thank you.
Thank you. And then we're ready on Hawkins?
Yes, Your Honor.
That's correct.
Okay, give me 2 seconds. Okay, on the record in the matter of the state of Michigan versus Eric Hawkins, 25-02366, appearance, please.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Here, Robinson, Assistant Public Defender for my client.
Okay, today is the date scheduled for a prelim on criminal sexual crime in the 4th degree. My understanding is that we're ready to proceed. Is that correct?
That's correct, Your Honor.
It's correct.
Any preliminary matters?
Yes, Your Honor. Briefly, first, I just want to place on the record that the people did extend an offer in this matter of assault and battery, a 93-day misdemeanor. My understanding is the defendant is rejecting that offer. At this time, upon calling the first witness, that offer is revoked, and upon bind over to circuit court, there will be no further misdemeanor offers. I wish for the defendant to acknowledge that and that he wishes to proceed to an exam on the record here today before we proceed.
Yes, sir, do you understand that we previously talked about the offer that was extended by the prosecution, correct? And that was to plead to that 93-day misdemeanor. And you decided that you did not want to accept that offer at this time, correct? And you understand that there's not going to be another misdemeanor offer in this case again?
Thank you, Your Honor. Additionally, the people are requesting a mutual sequestration order. The people are requesting, if the following people are here present in the courtroom today, that they remove themselves: Jalisa Ojeda, Meadow Sadal, Ileana Parker, and Eric Rutledge.
How are these witnesses?
They are potential witnesses as trial, as they were present during the party. And additionally, there is a co-defendant that potentially they could be witnesses for down the road as well.
Some people did leave the courtroom, I'm assuming those are potential witnesses.
That's my understanding.
Okay. A sequestration is granted. Any additional matters?
Not for the people.
No, Your Honor.
You can have a seat. You can call your witness.
Thank you, Your Honor. The people call Magdalene Young.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? Yes. You can have a seat. There's a microphone that's in front of you. The purpose of that microphone is so that the lady behind you can hear everything through the system, because a recording is being made and she has to be able to hear everything that you state, but that's not going to amplify your voice. So those of us in the courtroom need you to keep your voice up loud and clear, but specifically me, because your answers are so I can hear them, okay?
Okay.
If you need an answer or a question repeated, you can just ask to have that, or if you misunderstand something, you can ask to have it repeated. If there is an objection from either attorney, you stop speaking, because I have to make a ruling on that objection. And then I'll then advise you if you're allowed to give us the answer to their question, okay? If there's a yes or no question, I need you to respond yes or no's, mm-hms and uh-hs, or head nods and head shakes. They can't understand that on the record. So if you forget, we'll just ask you if it's a yes or no, okay?
All right.
State your first and last name and then spell both.
And spell.
Yes, spell your name.
Magdalene Young, Magdalen. Young.
Take your time. Okay. Again, if you ever need a break, you can just let me know, okay? You can proceed.
Thank you, Your Honor. Magdalene, I want to bring your attention back to April 13th of 2025. Were you at the location of 335 East St. Joseph Street?
Yes.
Is that in the city of Lansing?
Yes.
Ingham County?
Yes.
State of Michigan? And what's your relationship to that address?
I lived there in that apartment complex from October of 2024 to April.
Okay. Now, on that April 13th date, did you have occasion to be at apartment 14 in that building?
I I don't understand.
So what was your apartment number?
My apartment number was 8.
And at some point, did you go to a different apartment in that building?
Yes.
And do you recall what the apartment number was?
No,
Do you recall where it was in relation to your apartment?
it was right above mine.
Okay, and what prompted you going to that apartment?
My bathroom was like leaking, like the ceiling was leaking, and I was friendly with my upstairs neighbor, and I knew that she was having a party, so I went up there just to make sure that maybe one of her like guests didn't like flood her bathroom or something, you know what I mean?
And did you in fact go to that apartment?
Yeah, I went upstairs and knocked on the door, and my neighbor did not answer.
At some point, were you able to speak with anybody at the apartment?
2 of the people who were like 2 of her guests, one of them was Taviana, and one of the other girls answered the door, and I asked them if the bathroom was flooded, and they kind of got all confused, and they told me no, and so I went back downstairs to my own apartment.
And at some point, did you go back to that apartment?
They came to my door, my neighbor and all of them, they came down to my door. And I guess the people who answered the door before told my neighbor that I called the cops on them.
And what happened after that interaction?
My neighbor just wanted to ask, you know, and I told her I didn't, and I told her about the bathroom, and then we were talking for a while in the hallway, and they invited me upstairs, and they were a little persistent, so I went up there.
And what were you doing once you went back up there?
I was just like hanging around and talking to my neighbor, and at that time, Taviana.
Okay. And was Taviana someone that you had known prior to this interaction?
No, I did not know anybody there.
Okay.
The only person that I was like familiar with was my neighbor.
Okay. And do you recall what your neighbor's name was?
No clue.
All right. Male, female, something else?
Female.
And so you're in the apartment. What's happening?
Everybody was like sitting on the couch except for me, my neighbor, and Taviana.
Now, were you drinking any sort of alcoholic beverages during this?
I did drink a little bit of alcohol.
Do you recall about how much?
Throughout the whole night, I probably only had like 2 or 3 shots.
Okay.
I did not drink a lot, and I was really slow. I just wanted to like fit in, you know.
How were you feeling after those shots?
I wasn't feeling very drunk at all. And before I drank, Eric's and one of the other girls there were gonna like go to the store, and they were gonna drive there, and they were obviously not sober, so I offered to drive them to the store.
Okay. And at some point, did you come back to the apartment?
Yes, I came back with them.
And was there any point during the night in which something uncomfortable happened with this person you identified as Eric's?
Yeah.
Tell me about how that started.
I was already pretty uncomfortable when I was upstairs in the apartment, and I don't remember how it got to that point, but somehow I ended up on the stairs in the hallway alone with them. And I remember he kept saying it was okay, and he like approached me, and I said no. And he grabbed me.
How did he grab you?
It was like really quick.
Do you remember where on your body?
Yeah, he grabbed my butt, and then he grabbed my chest, and then he put his hands around my throat, like all in one quick motion.
Okay. So when he had his hands on your butt, was it both hands?
Yeah, he like grabbed me with both his hands, and then they ended at my throat, and he held my throat for a while.
Okay. And how long were his hands on your butt?
It was quick, but he like grabbed it, you know what I'm saying?
And then you said that he moved his hands up to your breast, is that correct?
Yes.
And again, is this both hands?
Yes.
Both your breasts?
Yes.
And how long were his hands there?
Very quick, like maybe only a second.
Did he apply any additional pressure to your breasts?
He'd like squeeze me down.
Okay. And then you said that his hands made its way to your throat, is that right?
Yes, and he he was holding my throat, and I don't know how hard it was, but my mom, the next morning, she said that I had bruises on my neck, so it must have been hard, and he tried to get me to kiss him.
Was he squeezing your neck at all?
A little bit, I don't know, but I had bruises on the side of my neck. I had a lot of adrenaline in the moment.
Do you remember if you were able to breathe normally while his hands were on your neck?
I think I could still breathe, yeah.
Okay. Was it normal breathing or was it different?
It was normal.
Okay. So, so he touched your butt and your breast. Was he saying anything while he was doing this?
He kept saying that it was okay. Like, he just kept saying it's okay, and I kept saying no, like over and over again.
Were you expecting him to grab you?
No, I was not.
And what were you guys talking or anything right before this?
I don't remember.
Okay, so tell me a little bit about not remembering. What do you think makes you not remember?
Right after that, I went upstairs and I was attacked.
By somebody other than?
Yeah, I was attacked by Javiana.
Okay.
I had went back up there to go grab my shoes. And when I went to go leave again, that's when she pushed me and she punched me in the face, and she pushed me down on the ground and she stomped on my face like 7 times. So I haven't had the best memory since I hit my head.
Are parts of the events clear in your memory?
Definitely.
Okay,
Yes.
Which parts?
Probably from when Eric touched me to until I got to the hospital and all that. Like, I remember my assault very clearly.
How were you feeling when Eric was touching you?
I was uncomfortable and I told him no.
Now, at that time, did you know who Eric was?
No, I didn't even know his name until I was told.
Okay. Was there anything distinctive about him?
He was missing one of his eyes.
Okay. Tall, short, something else?
He was tall.
White, black, Asian, something else?
Black.
Okay. Do you see someone here in the courtroom that matches that person that you remember?
Yes.
Can you point him out and describe something he's wearing?
He's right there with the white hoodie on.
Your Honor, at this time, I'd request the record reflect that witnesses identify the defendant.
Any objection?
No objection for purposes of preliminary exam.
So noted.
Thank you, Your Honor. Was that your last interaction with Eric?
Yeah. Okay. I mean, he was there. He stuck around when I was attacked. He sat there and watched, but other than that, I had no other interactions. They all left.
I have nothing further at this time.
Cross exam.
Ms. Young, you stated that you were attacked immediately after the incident, after the alleged incident with Mr. Hawkins. Is that correct?
Yes.
And did you go to the hospital for this?
Yes.
Okay. And did they diagnose you with anything there at the hospital, if you can remember?
Just my contusions and lacerations on my face and on my chest.
I know you said previously that you've been having issues remembering things since the incident. Can you explain more about that?
My memory is just not as good as it used to be before the event. I have a hard time remembering a lot of things. It's not just that night. So.
And when you say a lot of things, could it be like details of things? What are you having trouble
Definitely
specific?
like details of things, like any of like event, like my day to day. I don't know how to, I'm sorry.
That's okay. Besides Mr. Hawkins, how many other people were there at that apartment?
4.
And you stated that you took previously you drove them to a store, is that correct?
Yes,
And how many people did you drive to that store?
just Eric and one of the girls.
And did you drive them in your car or was it one of their cars?
Yes, it was my.
And the other people that were present in the apartment, were they white, black, Hispanic, Asian?
Three of them were black and one of them was Hispanic, I believe.
And were they male, female?
Everybody else is female.
After the incident, were you taken immediately to the hospital?
Yeah, I called 911 and they were there within like 5 minutes.
So you're taken by ambulance?
Yes, it was.
When were you released from the hospital?
It was late the next morning. I don't know the exact.
Were you ever diagnosed with having a concussion?
I don't think so.
You don't think so, or do you not remember?
I don't remember.
That's okay, just trying to be clear for the record. You stated prior to this night in question, you did not see anybody or with the other people there besides your neighbor, you didn't recognize anybody else there, correct?
No, I've never seen any of these people before.
I have nothing further.
Redirect.
None, Your Honor, thank you.
Thank you. You may be excused. There is a sequestration order, so you're not to discuss your testimony with any other witness, okay? Thank you. Call your next witness.
Thank you, Your Honor. The people is called Detective Kenneth Schaefer. Schaefer. Thanks, David. You went downstairs. Thank you.
Yeah, the officer leaving. I'll get snapped. What's going on?
He's coming up, okay. Sorry. No, you're fine. Yes. He said he's coming up. We got a hold of him on the phone. Thank you, David.
You're welcome.
County, state of Michigan. Additionally, the victim in this matter pointed out the person that is accused as being the defendant. The detective pointed out the defendant as the person who matched the individual that he located in the Secretary of State as the accused, and his friend or his friend's cousin today also identified him as being at the party. So I believe date, venue, and ID have been established by a probable cause standard. So we are left with the elements of criminal sexual conduct in the 4th degree. We have here from the victim, Miss Young, that the defendant did grab her on her butt, moved his way up to her breast, and then towards her throat. That he tried to kiss her, that she was telling her no, or that she was telling him no, and that she was not expecting him to grab her like that. This is charged under a force or coercion theory. Force or coercion for criminal sexual conduct in the 4th degree can include surprise. Given the sudden grabbing of her, it is the people's contention that the elements of criminal sexual conduct in the 4th degree have been established, as he did grab her butt, which is a listed location, and he did so using force or coercion, and the fact that he tried to kiss her after is probative of the fact that he was doing it for sexual gratification or a sexual purpose. Additionally, the people are asking for an added count of criminal sexual conduct in the 4th degree for the defendant touching Miss Young's breast for the same reasons as the elements under the previous charge I mentioned. While I understand that the defense has put up a witness that indicated she was with the defendant the entire night, didn't see anything happen other than a fight. She is friends with she is cousins of the defendant's friend who was also involved in this altercation. I believe that her credibility is questionable, and this is a question that should be left for a trier of fact. Thank you.
Yes, Your Honor, we would request that you do not find probable cause in this manner. In this case, we heard from basically 2 main witnesses. The alleged victim in the case, who stated herself that she was drinking that day, and that she did suffer a concussion afterwards from an unrelated from my client fight that occurred.
I thought she wasn't sure if she had a concussion.
Or I'm sorry, you're right. She did say she wasn't sure she had a concussion, but she did say that she was stomped 7 times in the head. So I apologize about that. And she stated that since that incident that she wasn't able to remember, it's harder for her to remember details of things, and her memory wasn't as good as it used to be. We did hear from Kylena Parker, who testified that Mr. Hawkins was with her for the entire time that they were together at that party, and that she did not see him alone with Ms. Young during that entire amount of time. So we'd ask that you do not find probable cause.
Thank you. Today was a date set for preliminary examination. So that means the burden at this point is on the prosecution to establish more than mere suspicion that the felony that you've been charged with was committed. This is not a trial. They don't have to prove each element beyond a reasonable doubt. It's a pretty low burden at this point. The court will be the only determiner of credibility issues, and also weigh the likelihood of the prosecution's success at trial. Again, in count 1, you're being charged with criminal sexual conduct in the 4th degree. The elements is that the people would need to prove at trial beyond a reasonable doubt that the defendant intentionally touched, in this case, Magdalene Young, or made, permitted, or caused Miss Young to either touch your genital area, groin, buttocks, or breast, or clothing covering that area. Second, that the defendant touched Miss Young, or when he touched Miss Young, or made, or permitted, or caused Miss Young to touch him, it could reasonably be construed as being done for any of these reasons. Sexual arousal or gratification for sexual purpose in a sexual manner for revenge or to inflict humiliation or out of anger. And then the people are charging this under force or coercion for the purposes of sexual gratification. The people are also asking for an added count 2 of criminal sexual conduct in the 4th degree for the touching of, or the alleged touching of Ms. Young's breast. I believe this one is charged for the alleged touching I believe, of her buttocks. Is that correct?
That's my understanding.
Okay. And so we had testimony today from Magdalene Young, who stated that on or about April 13, 2025, she was present at the area of 335 East St. Joseph's, that her apartment, or this must be an apartment complex, but her apartment is in apartment 8, but that she went up to the apartment just above hers. She stated she went up for the purposes of her ceiling leaking, and that the neighbor was having a party, that she spoke to 2 people that she wasn't familiar with, asked if the bathroom had flooded, that those individuals appeared to be confused, and that later she returned to her unit, and later the neighbor came down because she thought maybe Miss Young had called the police, or was told that Miss Young had called the police. And to which Miss Young said she didn't call the police. And then Miss Young's testimony is that she was then invited upstairs to the party, and that the individuals were insistent that she attend this party. She testified that she did know the individual, I believe, named Taviana, but she was not really familiar with anyone else upstairs, and that she had gotten along with her neighbor up to this point. She stated that during this time she had about 2 or 3 shots. She testified that she felt okay at some point and that she was not under the influence, but that she felt uncomfortable while being in the upstairs apartment. She somehow, is what she said, ended up in the hallway, stairways, or some stairwell or of some sort with, she said, him. The court later understood her reference to him being the person in the court identified as Eric's Hawkins. She stated that he grabbed her by the butt and the chest, but put his hands around her throat with both hands in a quick motion, held her throat for a while, attempted to kiss her, grabbed her, again, buttocks and then her breast with both hands. She testified that he squeezed her breast. She stated that a short time after that, she was attacked by Taviana and suffered some injury, and she believes, or she reports, that there's some memory loss, or her memory is affected somehow. The person that she identified as the individual who allegedly did the touching was someone who she described as a tall Black male missing one eye, that she pointed out in court, but believe she states she didn't know his name. Let's see, and she did suffer, she said, some lacerations and contusions. It's unclear if she had a head injury or a concussion from the separate alleged attack. She said that she called 911 and she was transported to the hospital by ambulance. We had testimony then from Officer Kim Schaefer, who appeared, I guess, for the purposes of largely identifying the defendant by name and based from the course of his investigation. The defense called a witness, Kylina Parker, who also testified that she was present at the same address for a get-together amongst friends, that she said that if she'd been there for some hours, it was late when she arrived. She stated that a neighbor came upstairs. That neighbor she described to be the person the court believes is the victim, or the alleged victim in this case. And that the neighbor originally came up to ask or for them to quiet down, but then asked if she could join the party, which they thought was weird because she says no one knew of this individual, but that neighbor then joins the party. She testified that she never at any time saw the defendant, Mr. Eric's Hawkins, alone with the alleged victim. She did also testify that there was in fact an altercation between the neighbor and Taviana. She also testifies that she's cousin with Daviana. Okay, the prosecution is arguing that her credibility, her being Miss Kyliana Parker's credibility should be questioned because she is a cousin or relative of Daviana. Just because they're cousins doesn't mean that I need to discredit her testimony. I think she was pretty forthcoming even in her response to that. She says everyone has to essentially take accountability or have consequences for their own actions, which is the truth. However, I don't know that her testimony would completely discredit all of the testimony of the alleged victim, because it really, I think, only creates a question of fact. It's either happened the way Carlina says, or it happened the way Magdalene says. So there's a question of fact there. Now, as to credibility, again, I found Ms. Parker's testimony to be credible. However, just because one person who's present when there's 6 or 7 people around never sees 2 people alone doesn't mean it doesn't happen. It just means I didn't see it. That's all that means. The other thing is, I do find there to be some credibility issues with the alleged victim's testimony, just because it defies common sense for there to be a get-together of people that you don't really know, and that obviously your bathroom is leaking, and then somehow you decide to abort that concern and go to a party because people you don't know insist. Doesn't sound normal to me. It does sound normal. What Ms. Parker said is that there was some noise and she came up to ask them to quiet down. That sounds reasonable. I would imagine it's weird even if she asked to join the party. I think it's weird if she asked to join the party, and I think it's weird if they asked her to join the party. Either way, there's a question about how she joined the party. But nonetheless, we know she joined the party. And then she's at this party, she's drinking, she had a couple of shots. The other issues that I have credibility with is the fact that she only gets foggy after she's very clear about the alleged assault. And so it's a selective issue with her memory. And so that's where my questions are. But I'm not discrediting that there was an incident where she ended up in the hallway, possibly with the defendant, and that there was some physical touching. I just don't believe that she doesn't know how she got there. I believe she knows how she got there and intentionally left that out. But I have to leave that to a jury to figure out how she got there and why she went there and whether or not that was for an intentional or consensual situation or not. I don't know. With that being said, I do believe that there is sufficient probable cause, even with my concerns or questions, to bind count 1 over to the circuit court, and sufficient probable cause to add count 2 for the touching or the allegations of touching of the breast. And those count 1 and 2 will be bound over to the circuit court for further prosecution. Bind over date is, what is today's date? The bind over date is going to be the 4th of March. That's the date the circuit court will receive this file. It's not a date that you have court, okay? Your next court date will be a pre-trial in circuit court. Your attorney will be made aware of that date, okay? You stay in contact with Ms. Robinson. And let's see, there was a PR bond that will continue in a no contact order. I believe it said that you were supposed to be on GPS tether, but GPS tether also was not checked. It was just written on there. Are you on GPS tether? Okay. Any additional matters? That will continue. Any additional matters for the record?
Nothing for the people, thank you.
No, Your Honor, thank you.
Thank you, you're all set. Was supposed to be the case? Is that how it's done?
Well, we don't have.
Because it said it was before Judge Ward originally doing it.
I
Warrant status, so
She never appeared.
Yeah, I didn't
Just do.
Okay, I know what you.
Okay. And then I'll give you all the information.